Diseases don't discriminate, people do. And so we have to get out there and do the education and outreach that is needed. Bring all of our stakeholders in. So the LGBTQIA plus community, our business members, other community members, because we all need to do this together as a village to be able to take care of one another. So once again, thank you to our caucus here and our council members for taking the leadership that we need as a community. And I look forward to working with all of our partner organizations to make sure that we do what needs to be done to keep our community safe.
Thank you, David. And now I'd like to invite Zephyr Merker-Herrera, Outreach Coordinator at GMHC, to give remarks.
Hello. I know many people up here have already thanked the caucus for putting out this legislation to codify many of the efforts that we have done, so thank you again. I am a client-facing worker at GMHC. My day-to-day business is HIV testing prevention. So I'm used to speaking to people when they're anxious, as many people are when they wait those 20 minutes for a rapid HIV result. And now I'm facing with more people coming in anxious because they don't know what their sex lives are going to look as such. And sexual health is important. People are coming in, they're scared. Many agencies have been partnering in order to try to navigate people to the monkeypox vaccination portal, which we know has had many issues. And I am in agreement with Latino Commission on AIDS that having to be the ones putting the burden on the equity push of the vaccination has been challenging, especially as we aren't funded for doing this work. We are doing it because we know it's important, it is urgent, and we are spending the time away in addition to our everyday duties adding this work. We are burnt out, we are fatigued, and we need support to get the people who are most impacted, people of color, those of us in the community, transgender people, and people who are engaged in contact sex work, because they are having to face, should they get sick or should they have work and pay rent? Thank you.
Thank you. Thank you, Zephyr. And now Paul Nagle, Executive Director of Stonewall Community Development Corporation.
Hi, thank you. I'm the Executive Director of Stonewall Community Development Corporation, where our goal is to see New York City's LGBTQ older adults in safe, welcoming housing they can afford, with access to health and mental health services that meet their unique needs. I'm also a 64-year-old gay man who survived full-blown AIDS and lost all of my friends at that time. And the reason I'm alive is because I joined an illegal buyers club. I broke the law, and I saved myself, basically, at the same time that I was ministering to friends who were dying. Right now, I have a friend who's got monkeypox, and we're waiting to make sure that it doesn't get into his eyes, which is a whole new adventure for us. I'm really proud of the community, and I'm very proud of the caucus. Their focus on evidence-based systemic responses is really awesome. And from actually citing the lack of evidence, data collection that would create the evidence that we need to base these strategies on. So I would urge that we get the education materials out and that they be very frank and culturally specific, because that was a very important turning point in fighting AIDS. Thank you very much for the opportunity to speak here.
I want to remind our viewers we are on standby any moment. We will see Attorney General Garland stepping out at the Department of Justice briefing. As soon as he does, we will be taking that live, raw, and unfiltered for you right here on Live Now from Fox. Still have not heard word on what the briefing is exactly on, but of course we will be taking it in full for you as soon as he does step out. It was set to take place here about 4 minutes ago, so we are expecting these statements to be had any moment now. Again, we'll be taking that in full as soon as that does happen.
Okay. So very quickly, on behalf of exponents, queer and trans participants, and the thousands of Black and brown community members, exponents thanks you for your diligence, your leadership to the LGBTQI caucus, as well as Lynn Schulman as the chair of health. Over the past 3 weeks, exponents has had the opportunity to partner with New York Knows. I want to send a special shout out to Amanda and Patrick. We have been able to provide over 200 appointments to vaccinations to Black and brown folk across the city. That's a drop in the bucket. But the reality of it is until we figure out how to de-link protection from privilege, until we figure out how to stop penalizing people for poverty, we're going to continue to see situations like this. The individuals that we've seen access vaccination appointments include professors and men and women from the sex industry, House ballroom members, and immigrants. And I share that to share how the importance of connecting availability to access opens up doors for everyone from every walk, and that's really, really important. We've seen individuals create informal networks where I'm registering one individual, and when I get done with them, they'll say, hold on, I've got a friend here. And I've literally enrolled 5 or 6 different people from one phone call. That speaks to me about the passion that people have to protect themselves, especially when you superlay that on food and poverty, housing insecurity, threats and violence against individuals based on sexual orientation and gender minorities. So one of the things in closing I want to say is that New York has always been a trailblazer addressing public health emergencies like HIV, COVID-19, and racism. We look forward to working with co-chairs Caban and Hudson and the entire caucus as we collectively move forward to ensure that our community members are navigated to the intersection of availability and access for up-to-date information, testing, treatment, and vaccinations. We thank you all for your efforts, and we hope to continue to partner with you.
Thank you so much. And now, Elisa Crespo, Executive Director of New Pride Agenda.
Good morning, everyone. My name is Elisa Crespo. I'm the Executive Director of the New Pride Agenda. I, of course, want to start by saying thank you so much to the LGBTQ caucus here in the New York City Council, to the chair of the Health Committee, Lynn Shulman, to the co-chairs, Tiffany Caban and Crystal Hudson, for your leadership on this very important issue. Much has already been said, but I do want to center a few communities who are very vulnerable and at high risk. We cannot forget about sex workers when we are talking about MPV. They are at very high risk of contracting the virus. And so we have to incorporate sex workers into any action plan that we have or that we are putting forward. We cannot people who are incarcerated on Rikers Island, people who are on state prisons and jails in all 62 counties across this state. They must also be centered and part of any action plan that we put forward to eradicate MPV here in the city and state of New York. And I am also so thrilled that a part of this package is an effort to provide transparency on who exactly is getting vaccinated. We know who is testing and who's testing positive, but we have yet to receive any information publicly about who is receiving the vaccine, and that is crucial and important to be able to understand how to eradicate this virus here in this city. So again, I want to thank all of the agencies who are here, who are on the front lines. New York City is the epicenter of the epicenter, and you all are doing an incredible job. So thank you so much for taking care of our community in the ways that you do, not just with MPV, but with anything and everything health-related in our community. Thank you so much.
And thank you. That concludes the end of our remarks, so we can answer any questions that folks may have.
All right, so again, New York City Council introduced some new legislation all surrounded the monkeypox response, encouraging the city to come up with a response plan to do community outreach and also get more vaccines available to those who are the most at risk. Do want to remind everyone we are on standby here. About 8 minutes ago is when this press conference was supposed to be starting. Attorney General Garland expected to make a statement during the Department of Justice's briefing. Unknown exactly what this briefing is going to be on. Any guidance that we have just says Attorney General Garland is set to make remarks here alongside others in the DOJ as well. So we will be continuing to keep you on top of this live picture right here for you on Live Now from Fox 2. Also still have a live picture coming to us out of Mar-a-Lago, which is exactly what a lot of people are hoping is what the Department of Justice is going to be speaking about that most recent FBI raid that happened back on Monday at former President Donald Trump's estate. So it's not only there in Florida that Donald Trump has been facing some legal trouble. He's also been facing some legal trouble out of New York when it comes to his business practices. We'll be breaking down some of these issues right here for you in a while, right after these remarks from the Department of Justice. So as soon as this does happen, this is what we'll be breaking into here for you on Live Now from Fox. Of course, though, going to continue giving you some more of these top stories, news conferences happening all across the country. We've been listening in to a trial that's happening out of California, where we do have Scott Peterson, who was recently convicted. Actually, he was convicted back in 2004 for the murder of his wife and his unborn son. Well, now his attorneys are saying that they had a potential juror misconduct happening. So they are throwing out a bid for a retrial. This has been something we've been listening into here for a little bit on Live Now from Fox. Let's go ahead and listen back in the courtroom, but I do want to let all of our viewers know as soon as we do see the Department of Justice stepping out to that podium, beginning their briefing, of course, that's what we'll head into in full for you right here on Live Now from Fox.
To be fair.
Correct.
Fair person. Okay.
And so her answer is, yeah, I tried to be. And again, this is Miss Nice from back in 2004 to what the court saw here during the evidentiary hearing. Can you explain to me why you believe yourself to be a fair person? Answer. Because I know what it's like to be judged, and I know what it's like to be prejudged before somebody actually, how many times have you walked in a room and someone has automatically pinned you for a certain type of person, and that's completely opposite of how you are? So, question, okay, answer, I try. That's Miss Nice telling us way back then. This is the kind of person she is, and she's going to attempt to be fair in this particular case. I'm going to go through a list of things, because counsel's saying you have to look at the totality of the circumstances. Well, Miss Nice testified during her voir dire in the hearing here. She hoped she could be a fair juror for the petitioner. That's part of Exhibit 5. She had no opinion based on pretrial publicity, was open to the possibility that he was falsely accused, had no fear of finding the defendant not guilty, responded to the questionnaire candidly, truthfully, and to the best of her ability. Confirmed that at no time during the jury selection process did any court case in which she was involved cross her mind, nor did she think about them when filling out her questionnaire. She did not intentionally omit any incident with Ms. Kinsey, since they didn't come to mind. The incident with Eddie Whiteside never crossed her mind. She did not form any conclusions regarding the evidence in the case until she was called into the jury deliberation room, and she recalled discussing the evidence with the remaining jurors before a unanimous verdict was reached. She had an abiding conviction that the charges were true on the evidence that was presented at trial, and her abiding conviction was solely based on the strength of the evidence presented at trial. She had no bias against Scott Peterson. When she was selected as a juror, she listened to all the evidence and decided the case based solely on the evidence in the courtroom and not some preconceived notion. That's the facts that have been presented to the court. Those are the undisputed claims or statements of Ms. Nice about her involvement in this particular process. So what do we have from the defense? What do we have from the petitioner in this particular case? They start with their claim one, which is that she was out to get them and she didn't indicate that she was involved in a lawsuit. So the standards, we start with Manriquez, as counsel indicated. The habeas petitioner bears the initial burden of showing that a juror did not disclose requested material information. Material being an important part. More importantly, though, an intentional concealment is strong proof of prejudice, while showing that a non-disclosure was unintentional may rebut the presumption of prejudice. Whether any disclosure was intentional or not is not dispositive. And then the court goes on. The ultimate question is for whether the juror was a substantial likelihood that they were actually prejudiced or biased against the petitioner. So in this particular case, starting with that particular framework, even though counsel says if there is a false statement, the burden shifts. That's not exactly what Manriquez says. Manriquez actually is saying you may even rebut the presumption if it's unintentional. So it's a little ambiguous as to that particular point. Then
So
there's...
let me go back to Exhibit 1. And in the caption page, and Ms. Nice said this was her handwriting, it doesn't use petitioner and respondent. The form says plaintiff, and she filled in Rochelle Neese, and defendant, Marcella Kinsey. You'd agree that terms plaintiff and defendant can be inferred as parties to a lawsuit, yes?
There's a potential that you can infer that, but I would point the court to page 7 down at the bottom.
Okay, just
We
a moment.
start... So at the very bottom, there's something that appears to be typed in.
You know, these are not Bates numbered. Let's see, just a moment. There's a handwritten number. I have 9.
What I'm going to point out to the court at the bottom, and I believe it's in the lower right-hand corner of that particular exhibit, it's typed in, it says civil.
Okay.
So this is a petition for an injunction, looking at the caption of the paperwork. A petition for injunction prohibiting harassment. This doesn't say lawsuit, it doesn't say crime, it doesn't say anything that might lead an ordinary person to say, I think this is a lawsuit. We pointed out in our briefing, and I'm just going to highlight this again because as the court indicated, U.S. Supreme Court has indicated, we're bringing in lay people off of the street, and all of a sudden we're asking them to understand the legal terms that we use that we take for granted. How many times have we heard jurors sit in the box and say, my house was robbed? A house can't be robbed legally. So they're wrong. But they're telling you what they believe is the circumstances in that particular case. It was a burglary, it was not a robbery. So they're wrong about what the crime is, but that does not make them a liar. So the fact that Ms. Nice in this particular case does not think that a civil petition for an injunction prohibiting harassment is a lawsuit doesn't make her wrong. Maybe legally, if this court wants to say, I believe this is a lawsuit, then by law, by definition, she would be wrong, but is that unreasonable?
Well, how do you respond to Mr. Gardner's position that then there is, I know the people's position is there's no document in front of the court that establishes that Ms. Nice filed a second lawsuit for damages, but her testimony is that she filed something, a lawsuit, I believe, was the term that she used for, she wanted money from Ms. Kinsey. So how do you reconcile that?
So how we reconcile that is when she's asked about that, going to reporter of the transcript, page 42 through 43, starting at line 18. She was asked, was this about some civil suit for loss for money? And her response was, I guess. It was with Marcella. She did say she went to court, but that's where she said she dismissed it. It was over with, and her and I came to the realization that we were both being stupid, and this was over a stupid guy, and there was no need to continue. And that's at reporter transcript 94 through 95. So what we have here is an equivocal statement on her part that there may have been a second suit. That could have been because it's the burden is on the petitioner to prove that there was a lawsuit. Because if they prove there's a lawsuit, then they prove that her answer is false. So this is the initial pleading and proof stage. They must prove that there was a lawsuit. We never heard from Ms. Kinsey. We never heard from the custodian of records for the court that shows that there was ever a case that was filed. Now they're limiting it to saying, well, you know, we didn't show any paperwork. That's true. They had on their witness list the custodian of records. The custodian of records could have come in and said we had a filing, or they could have said that there was no filing. But we know from the other exhibit, that's the temporary restraining order for the civil harassment, there was paperwork from that same time period that existed. There's not a transcript, not everything is there, but there's at least minute orders. So if there was something that was filed, it should be in the record They had the witness that could have presented it on their witness list, and they never called.
All right, but we also have a jury instruction that says that the testimony of one witness can prove a fact.
That is correct.
Okay.
But our position is, we pointed out to the court in our briefings, Ms. Nice showed sometimes that she could be a little bit confused about things. And you saw that with some of her answers when she just started to say, sure. And when she would then be given the appropriate circumstances or shown a document, she then could explain it. And I'll talk about that a little bit later with some of the slides that were up on the screen. I also want to point something out. Counsel has indicated, and this is a subtle distinction, but the court will remember this, that exhibit number 1 was admitted, the letters were admitted, and I want to remind the court, we objected, and they actually were admitted for a limited purpose. So those particular items are not actually in for the truth of the matter. They were in for purposes of impeachment against Ms. Nice.
Well, and also, I believe, state of mind. So the letters were admitted, but not for the truth, but for state of mind of Ms. Nice, correct?
Correct. So
Okay.
then again, not for the truth of the matter. So when they were referring to the letters about what they claimed to be there, it has to be directly connected to Ms. Nice's state of mind. Otherwise, there's no connection. There's no admissibility for those particular items. We suggest to the court.
All right, guys, we've been listening in here in California. Scott Peterson has again filed for a retrial. His attorneys arguing the case should be retried based on what they say was juror misconduct. We're listening in here live to that courtroom. Do want to report also we're hearing from multiple different entities that the Attorney General Garland will be speaking on that FBI raid of President Donald Trump's Mar-a-Lago home. So, of course, we will be taking that in full as soon as that happens. He was set to come out and make some remarks during their briefing about 20 minutes ago, and it looks like they're running a bit behind. So as soon as they do step out to that podium, we'll, of course, be taking that live on Unfiltered for you here on Live Now from Fox. Until then, going to continue listening in to attorneys for Scott Peterson. Again, back in 2004, he was convicted for killing his wife, Lacey, and their unborn son, Connor. But right now, they are saying there was juror misconduct that should lead to a retrial.
There's no testimony of that, but there is a minute order from that court file that shows that she was there. And that helps the court address another question that was not really answered by the petitioner about what did that judge have in front of him. That minute order also tells us that Ms. Kinsey testified. So that judge had the testimony of both the petitioner and the defendant in that particular case. And it's a total job of speculation to try and figure out what it was that was said, and that would be completely inappropriate. But they're asking you to say, we want you to think bad about Ms. Nice because, that's Ms. Nice. Again, speculation doesn't work that way. And we've pointed out also in our briefing, the evidence code section, that it's their burden producing the evidence, and if there's other evidence that they could produce, they could have produced Ms. Kinsey. That would have resolved this particular issue. And this is their initial burden of proving the lawsuit. So it was not our burden to produce Ms. Kinsey to say whether there was or wasn't a lawsuit. That was on them. So evidence code section 412, as we cited, just read it real quick. If weaker and less satisfactory evidence is offered, when it is within the power of the party to produce stronger and more satisfactory evidence, the evidence offered should be viewed with distrust. The failure to call a logical witness is a failure of proof on the petitioner's part. And you'll see this repeated throughout these different things. We didn't hear from Mr. Whiteside. We didn't hear from one of the jurors that they talked about money. So their burden, their responsibility to produce the evidence. So just to put this out there, the first restraining order, the people do not submit that was a lawsuit. In fact, the people would say to a civilian that was probably not. She didn't think that was a lawsuit, and that was entirely reasonable. As to the lawsuit for money, yes, Ms. Nice was very equivocal about that, but She didn't recall the event of coming to court and testifying, showing that she's just not clear about that time period.
But you recall coming to court.
Well, she recalled coming to court filing the paper. She didn't recall the court coming back when she testified at the hearing as depicted in the minute order that was being shown to her. So the fact that a significant event, or what should have been a significant event of her going to court and having this hearing, she doesn't remember, when she's asked about this all these years later, just again shows the point that the people have been making. With Ms. Nice, you got what you got. She's a very straightforward, sincere witness. She's telling you, very much telling you what's on her mind and what she thinks about things. That she called it the way she saw it. We may not like that. As the court said, we may not have the same lens that she has. I think that's kind of an understatement, but that's Miss Nice, and that's her telling it from her point of view. So the fact that she didn't remember the circumstances of even the one that she admits she was involved with, when it comes to the lawsuit for money, the people's position is that really was part of the restraining order. She was shown paperwork from the restraining order and asked about these finances. She didn't recall, said it wasn't her handwriting, but she was asked about that. It's the people's position, they were part of the same thing. And our speculation is just as good as the petitioner's speculation when it comes to there being a second lawsuit. So.
Well, but she used the term, I dismissed it.
Correct.
And it suggests, if you will, a reasonable interpretation. If you're dismissing something, that means you filed something because you're going to court and you dismiss it. But so that's another reasonable interpretation. Agree?
Yes, but
okay.
If there are two reasonable interpretations, there is that instruction that would be used in a criminal case. The one that indicates towards innocence in the criminal case would be the one the court would have to follow. Here we are in a habeas proceeding where the law says everything in favor of the conviction is the way that it should be applied. So if we were to take kind of bootstrapping those approaches here, we would find that we have to go with the one that just Ms. Nice was mistaken. But regardless, she was sincere in her testimony saying that neither, whether it was one or two, she never thought about them. They never crossed her mind when she was filling out the questionnaire because these things were behind her. She had dropped the matter or dismissed it, according to her statement. As I read the statement earlier, she and Miss Kinsey had figured out this was over a dumb guy, and she had put it behind her.
Well, but not so much behind her that she said she called about Miss Kinsey holding the baby in the video. So how should the court reconcile that?
The circumstances in that particular case are, as she was describing it, she was shown a video where she saw Miss Kinsey holding her son. And she believed that she called a family friend who just happened to be a detective, I believe is what her testimony was. We asked Ms. Bracksher about that, which is another witness we'll get to in a few minutes, but with Ms. Bracksher couldn't tell us what the entry on the screen was, that basically there was nothing that occurred, nothing, I don't recall what the specific wording was, and she said, I don't know what that means. You'd have to pretty much ask the officer. That's up to the officers to put those things in there. So once again, that's something that the defense, knowing who those officers were because they communicated with Ms. Bracksher, got the information who the officers were, could have called those particular people. They could have called Mr. Whiteside. They chose not to. And as the court indicated, he was a subpoenaed witness, and they were attempting to get in his statements through their investigator. So this was not somebody that was a surprise, somebody they didn't know about. This was just somebody, they didn't want to take the risk of putting him on the stand, as counsel indicated. That, unfortunately, pursuant to 412, that doesn't work that way. You can't then, when you have that evidence available to you, you can't then turn around and say, well, it's not our problem. Well, it is their problem. The presumption is that what they offered should be viewed with distrust.
All right, so we are up at the noon hour. We're going to resume at 1:30. Thank you. I'm not putting you on a clock, but about another hour.
Hopefully. It
All
depends
right.
on the amount of questions from the court.
All right, and then, Mr. Gardner, do you want to have 20 minutes to respond, or you don't have to?
20 minutes would be great. I'm sure I can do it in less.
All right, thank you.
Thank you, Your Honor.
All right, so a brief break going to be taken here in the California courtroom, still on standby for our Department of Justice briefing. Now, we are hearing word from many other entities in the media saying that Garland is going to be speaking on the FBI raid of President Donald Trump's home in Mar-a-Lago. Again, we had those live pictures coming to you from Florida. We've also been keeping track of the former president's movements, especially since down in Florida has not been the only place that we've seen some new legal battles happening. We've also seen in New York City, we've had the New York Attorney General investigating his business practices. So that's going to be something we're going to continue to keep an eye on, is all of these different things involving the former president. Again, he was under oath Wednesday in the New York Attorney General's office. Again, this is a civil investigation into his dealings. And he did say he declined to answer any of the questions they had, pleading the fifth. Now, that's something that a lot of people have been questioning and concerned about, especially since there's been previous times when President Trump has said that those who plead the fifth, if you're innocent, why would you take the Fifth Amendment? So we'll be talking about that coming up a little bit later here on Live Now from Fox. But again, just going to be on standby here for the Department of Justice's briefing. Also, we had earlier here this morning, a armed suspect try to break into the FBI office in Cincinnati. It then had it went into a pursuit with Ohio troopers. Then after the pursuit had ended, it went into a standoff where they had exchanged gunfire. We did hear from some of our officials earlier here today. They did say that thankfully at this time, no officers had been struck during that gunfire exchange. But of course, they're going to continue to keep us up to date when they have more updates that they're able to give to the public and to the media. So we're keeping an eye on that situation here for all of our viewers as well. But right now, now more than a half hour late, still waiting for the Attorney General to come out and give his remarks here at the Department of Justice briefing. Again, at first, we weren't told exactly what this briefing was going to be on, but we are hearing a lot of other media outlets reporting that he is going to be making at least some remarks on Trump's raid at his Mar-a-Lago home. So let's go ahead and bring you, of course, more news content that's been happening all across the country. Today, there was a family and friends and even Congress men and women who were saying their final goodbyes to Representative Walorski. She was killed in a car crash in Indiana, and now we had some of her fellow congressmen and women making remarks at her funeral. Let's go ahead and bring you those remarks from Kevin McCarthy, who had some very kind words to say about the former representative. We're going to be listening in right here to it. And just a reminder, as soon as though we do see this briefing underway at the DOJ, of course, that's what we'll be taking in full for you here on Live Now from Fox.
Good morning. I'm Kevin McCarthy, and I work with Jackie. To Dean, to Mom, to the brothers, to the nephews and nieces, to the constituents, thank you for sharing her with us. To Zach and Emma's family, thank you for their service to the country as well. We all walked in, we saw August 17th born, then perfected on August 3rd. Like you, I was not ready, nor was I prepared for that phone call. Shocked, angered, bewilderment. Dean called me and I couldn't talk long. I wasn't ready. Talked to a couple other members. We didn't talk long either. Nobody was ready for this. I called Dean a couple days later to check on him. He asked if I could speak today. I said yes to him, but I knew in my heart, I don't know if I'd be ready now. But he talked about what we wanted to talk about today. When I thought about that, when I prayed about that, Jackie was prepared for today. Because Jackie's someplace else today. I know that because I know in 2 Timothy, for if you die with him, you will also live with him. I've known Jackie for more than a decade. You're going to hear a lot, and you know how Jackie lights up a room. I want to be honest with you. She doesn't just light up a room, she runs the room. When I came in today, we were driving in, and I was saying a prayer to prepare me for today. Prepare me for this moment right now. Because you've got to understand, with so many things that happen in Congress, it would be Jackie who would call me or be...
Good afternoon. Since I became Attorney General, I have made clear that the Department of Justice will speak through its court filings and its work. Just now, the Justice Department has filed a motion in the Southern District of Florida to unseal a search warrant and property receipt relating to a court-approved search that the FBI conducted earlier this week. That search was of premises located in Florida belonging to the former president. The department did not make any public statements on the day of the search. The former president publicly confirmed the search that evening, as is his right. Copies of both the warrant and the FBI property receipt were provided on the day of the search to the former president's counsel, who was on site during the search. The search warrant was authorized by a federal court upon the required finding of probable cause. The property receipt is a document that federal law requires law enforcement agents to leave with the property owner. The department filed the motion to make public the warrant and receipt in light of the former president's public confirmation of the search, the surrounding circumstances, and the substantial public interest in this matter. Faithful adherence to the rule of law is the bedrock principle of the Justice Department and of our democracy. Upholding the rule of law means applying the law evenly, without fear or favor. Under my watch, that is precisely what the Justice Department is doing. All Americans are entitled to the even-handed application of the law, to due process of the law, and to the presumption of innocence. Much of our work is by necessity conducted out of the public eye. We do that to protect the constitutional rights of all Americans and to protect the integrity of our investigations. Federal law, long-standing department rules, and our ethical obligations prevent me from providing further details as to the basis of the search at this time. There are, however, certain points I want you to know. First, I personally approved the decision to seek a search warrant in this matter. Second, the department does not take such a decision lightly. Where possible, it is standard practice to seek less intrusive means as an alternative to a search and to narrowly scope any search that is undertaken. Third, let me address recent unfounded attacks on the professionalism of the FBI and Justice Department agents and prosecutors. I will not stand by silently when their integrity is unfairly attacked. The men and women of the FBI and the Justice Department are dedicated, patriotic public servants. Every day, they protect the American people from violent crime, terrorism, and other threats to their safety while safeguarding our civil rights. They do so at great personal sacrifice and risk to themselves. I am honored to work alongside them. This is all I can say right now. More information will be made available in the appropriate way and at the appropriate time. Thank you.
Attorney General, the former president said this is
FBI agents?
Thank you all for your questions, but as I said, this is all I can say at this time.
All right, so the Attorney General not taking any questions, but some important key things were mentioned there that he said he wanted to point out that he did personally approve that search warrant of President Trump's Mar-a-Lago home. And of course, there was a lot of people who knew about it because former President Donald Trump himself had been the one who had talked about how they did come and raid his home. Now, another thing that was pointed out during this briefing was that not only did they have these copies, but they gave copies of those warrants to Trump's attorneys who were there present. So this again, just coming in here to our Live Now from Fox desk. Of course, we want to continue breaking down just some of these different issues, especially when it comes to these different legal battles that the former president has now been dealing with.